In this video, we're going to be talking about the seminal case of Hedley Byrne and Heller. The facts are as follows. Hedley Byrne had received a large order from a company called Easy Power. Hedley Byrne then, through its bank, had requested Heller and Partners, which was Easy Power's bank, to provide a statement as to its creditworthiness. Heller and Partners accepted the request and provided them with a statement stating, without responsibility on the part of this bank, Easy Power is considered good for its ordinary business engagements. However, Easy Power then went insolvent not long after, and Hedley Byrne, as a result, suffered great economic loss. Before going into the House of Lords' decision in Hedley Byrne and Heller, it might be useful to lay out the background behind this case. Prior to Hedley Byrne and Heller, the general stance of the law was that no claim in the action of negligence can lie when the only loss suffered was pure economic loss, that is, loss that was not caused by personal injury or damage to property, as in the case of Hedley Byrne and Heller. So when Hedley Byrne and Heller came before the House of Lords, this was their opportunity to revisit whether this principle was in fact sound and whether any exceptions should be made to this rule. The court held that on the facts of Hedley Byrne and Heller, Heller and Partners owed no duty of care to Hedley Byrne, and this was because in its letter to Hedley Byrne setting out its statement about Easy Power's creditworthiness, it had explicitly stated that the statement was made without responsibility on its part. In other words, it was a disclaimer that excluded its liability. However, and this is the most important bit, the House of Lords made it clear that had the disclaimer not been included, Heller and Partners would indeed owe a duty of care to Hedley Byrne, and assuming that all the other elements of negligence are proven, Hedley Byrne would have won. Each of the judges in the House of Lords gave broadly the same reason for why they thought Heller owed Hedley Byrne a duty of care. However, their explanations varied in terms of wording. Before seeing what their lordships said, it is perhaps useful to lay out a quote by Bagshaw and McBride's Tort Law textbook, which very helpfully summarizes in one sentence what the principle in Hedley Byrne is all about, and that is, if A takes on the job of advising B on a particular matter, and he indicates to B that B can safely rely on that advice, then A will owe B a duty to take care that he or she does not give B any incorrect advice on that matter. And as mentioned, this principle was expounded by the various lords in the House of Lords through slightly different accounts. Let's take a look at Lord Reid's speech first. His lordship stated, "A reasonable man, knowing that he was being trusted or that his skill or judgment were being relied on, would, I think, have three courses open to him. He could keep silent or decline to give the information sought. Or he could give an answer with a clear qualification that he accepted no responsibility for it or that it was given without the reflection which a careful answer would require. Or, lastly, he could simply answer without any such qualification. If he chooses to adopt the last course, he must, I think, be held to have accepted some responsibility for his answer being given carefully, or to have accepted a relationship with the inquirer which requires him to exercise such care as the circumstances require." Now, Hedley Byrne and Heller clearly falls under the second circumstance, and therefore the lordships held that no duty of care existed between Hedley Byrne and Heller. However, if the disclaimer had not been added, that would put the facts on the third category, and Heller would likely be found liable, as it had not exercised the reasonable care and skill that a bank is reasonably expected to have about investigating the creditworthiness of one of its customers. This is even so where there had been no contractual relationship whatsoever between Hedley Byrne and and Heller. This leads us nicely into the next speech, which is that made by Lord Morris. He stated, if someone who is not a customer of a bank made a formal approach to the bank with a definite request that the bank would give him deliberate advice as to certain financial matters of a nature with which the bank ordinarily dealt, the bank would be under no obligation to accede to the request. If, however, they undertook, even if it was gratuitously, to give deliberate advice, they would be under a duty to exercise reasonable care in giving it. They would be liable if they were negligent, although there being no consideration, no enforceable contractual relationship was created. Similar remarks were made by Lords Hodson and Lord Devlin. Lord Hodson states, there are circumstances in which the law imposes a duty to be careful, which is not limited to a duty to be careful to avoid personal injury or injury to property, but covers a duty to avoid inflicting pecuniary loss, provided always that there is a sufficiently close relationship to give rise to a duty of care. This quote confirms that even though the general rule is that no economic loss can be recoverable under an action negligence, where there exists a sufficiently close relationship, in Lord Hodson's words, or in the other judge's words, an assumption of responsibility, then pure economic loss can be recoverable. Lord Devlin's comment is also interesting. Wherever there is a relationship equivalent to contract, there is a duty of care. Where what is relied on is a particular relationship created ad hoc, it will be necessary to examine the facts to see whether there is an express or implied undertaking of responsibility. Finally, Lord Pearce confirms the types of transactions that this duty of care can arise. He states, to import such a duty, the representation must normally, I think, concern a business or professional transaction whose nature makes clear the gravity of the inquiry and the importance and influence attached to the answer. This effectively excludes regular social conversations, mostly from the scope of the Hedley Byrne principle.